Thank you so much, and thank you for having me. I was really excited to get a chance to talk a little bit about race and policing. It's not usually what I've been talking about lately because I kind of have it advertised behind me. I have a book out on the American feminist movement and mass incarceration. So it's not unrelated to race and policing. It just has more to do with sort of gender crimes and policing in that particular space. But I'm glad I got a chance to do it because I really have been asked to do more talks about race and policing because it's what everybody's thinking about right now and about the changes and what the future might hold. So I'm really glad that I have a chance to talk to you, and hopefully we can engage pretty deeply in the Q&A on these tough issues. So 2 days ago, I read something that I think exemplifies what's wrong with policing. And it happened just a few hours away in Colorado Springs. Isaiah Elliott is a 12-year-old and just a regular 7th grader, but for his ADD, which, as you can imagine, must make it hard for him to learn on Zoom. And so here is a picture of Isaiah with his parents. So that's him. Okay, so his parents are Danny and Curtis. And on the 3rd day of school, Isaiah and the friend that he was potting with were in art class. And Isaiah upset the teacher by not paying attention, and instead he was playing with a toy in his house. And it happened to be a toy gun. And here's the toy gun right there, right? That zombie hunter toy gun. Okay, so that's the situation. Now, if you've ever met a kid, say from 7 to 15 years old, especially a boy, you would know that they love to play with guns, especially toy guns. So let me just stop sharing that. Okay, so this teacher was not pleased about that. And instead of calling or texting the parents, she reported it to the assistant principal and then informed the parents that she had done so. So the parents call up the teacher and they call up the principal and they explain that Isaiah has ADD, that the gun is a toy, that they've taken it into their own bedroom, and that they would speak to their child, and from now on, he will pay attention and not play during Zoom class. But by then, the principal had, without informing the parents, sent a recording of that class, that Zoom art class, to the school resource officer. So yes, the pandemic has created a situation where your kids and your home can be recorded, and that recording, without your consent, can go to the police. And yes, schools keep armed police officers around kids. And no, they are not particularly shown to prevent school shootings so much as ensure that disproportionately Black kids who act out in school end up arrested as well as disciplined. So this officer came and the teacher told the officer this was a toy gun. She also told him that the parents were very upset with the call to the police because on account of their race, they feared the police. But the officer wanted the teacher to ensure him that there was no way the gun was real, which, of course, she couldn't ensure him that. And that was enough for the officer, armed with a real gun, to go to the Elliott household. Curtis let him in, and the officer demanded to see the toy gun to make sure it was a toy. So they showed it to him. And instead of saying, oh, I'm so sorry to bother you, just make sure to keep it off Zoom, and, I had to do it, Officer Stephen Paddock demanded to speak to Isaiah. And when he did, Isaiah was in tears. Now, Paddock isn't a social worker and he isn't a child psychologist, right? He didn't tell the distraught, crying child, don't worry, baby, no one's gonna hurt you. You just scared your teacher and you're a good boy and I know you won't do it again. Paddock didn't soothe this child's emotional wounds, which were developing right in front of his face. No. He did what cops do. And here I'm going to quote from the incident report. And yes, there was a police incident report for this. Quote, I expressed the seriousness of the situation to Isaiah and explained how this could potentially lead to criminal charges in the future. I reiterated the importance of being present and paying attention to his educational classes while doing the online learning curriculum. Now, as a professor and a teacher and the mother of a 9-year-old who's doing online schooling, I think about this pedagogical and social psychological technique. You get a kid with ADD to pay attention in Zoom art through threatening him to go to jail. I think that will instill a love of art in the child for sure. But not content with that admonition, and again, I'm referring to the police report here, the officer told Curtis before leaving, quote, and this is what he put in the police report, "I advised Mr. Elliott that if this behavior continued, Isaiah could potentially face criminal charges for interference with staff, faculty, or students of educational institutions." And if you're wondering whether that's a real crime, it is. But per the Colorado Supreme Court, it's really meant for adults who threaten people on school property. And although it applies to children, not paying attention and playing with toys on Zoom doesn't cut it as a crime. It only applies to impeding children and teachers by, quote, the use of restraint, abduction, coercion, or intimidation, or when force and violence are present or threatened. Now, I'm not saying that this officer was unprofessional. And in fact, that's part of the problem. He was professional. In his mind, he was enforcing the criminal law that keeps schools safe. And in fact, if you look at the police report, it said it was a life or death situation. In his mind, he was helping the world. And I'm sure he didn't imagine himself as the thing that Isaiah will remember as one of the scarier times in his childhood. To be sure, social science studies confirm that adversarial interactions with the police, like seeing a parent arrested, are some of the most poignant traumas a child can have. One 2014 study surveying the data declared, and here I quote, "Multiple regression model results showed that arrest exposure was significantly associated with greater behavioral and emotional challenges after controlling for children's age, gender, race and ethnicity, household income, caregivers' education, parenting factors, and other traumatic exposure." And given the data on police brutality and racial trauma, being Black was likely a compounding factor in Isaiah's trauma. After the incident, Isaiah told his mother, quote, "Mommy, I had butterflies in my stomach. I was scared and I thought I was going to jail." The school has suspended Isaiah on the ground that he brought a simulated gun to school, even though the school was on Zoom and it was his room. And they're standing by that decision, despite the parents' pleas up the chain to the superintendent and despite the national outcry. So, why do I start with Isaiah's case when so many others are more spectacular? I mean, no one died. Thank goodness the Elliots are military and Curtis had the discipline to remain calm in the face of this invasion of his home and terrorizing of his child. But it's not hard to imagine what would have happened if he was not so sanguine about an armed, uniformed officer in his home threatening his kid. What if he had spoken up? Or what if he, Curtis, had been armed, as many people in Colorado Springs are? It's true. Isaiah fared better than Elijah McClain, a case also on our doorstep in Aurora, who dared to walk while Black and ended up on the ground, vomiting, promising to be a good kid, and being shot up with the ketamine that took his life. It's true. Isaiah fared better than Jacob Blake's 3-year-old, 5-year-old, and 8-year-olds who witnessed their father shot in the back 7 times as he was entering the car they were sitting in, and who'll never run alongside their father again. It is true. Isaiah fared better than Lyndon Cameron, the 13-year-old boy with Asperger's, just shot by police and now fighting for his life after his mother had called for emergency mental health transport. But I use his case, well, because it just happened, but also because it's a perfect example of the mismatch between the expectations we have of policing and the reality. That intervention into Isaiah's life caused net harm in the world. Let me be clear, it did nothing good, despite what the school says, nothing. And it risked catastrophic harm. And what people don't realize is that this is policing. Policing mostly isn't solving murders, it's not catching robbers in the act, it's not showing up to home invasions and saving you. The majority of time, police are interfacing with ordinary people, with kids. Some of them need help, some don't. Some are committing minor offenses, some just look suspicious. So we know from law school and practice and everything else that the Constitution envisioned police to have limited powers to interfere in ordinary people's lives, much less than kill them, and that this limited power has to be justified and quantified by levels of suspicion. But today, the police have become the go-to for everything. Problem with a kid? Police. Something blocking the street? Police. You think a person is hogging a public bench? Police. So a CU Denver professor and I crunched the numbers, and they're telling on why the police are the go-to. So all the people afraid of defunding the police, they operate under the assumption that the police have been funded at a stable and optimal level, and that they're being funded that way now. When in fact, if you look at the numbers, police have been hogging municipal funding for years. Okay, so let me share the screen again for you. So, all right, we looked at crime rates and municipal expenditures from 1990 to 2017, the last day of data. And here's what we found. We found that crime rates precipitously declined, while cities' expenditures on police significantly increased. Okay, so in 1990, there were 12 violent crimes per 1,000 people, right? And at that time, cities spent an average of $182 in today's dollars per resident on the police, okay? Now compare this to 2017. That was the latest year of comparable data. There were only 5 violent crimes per 1,000 people. That represented a 56% decrease in crime. Yet at the same time, the spending on police per resident went up to $292, a 59% increase. And so at the same time, right, across the 1,088 largest municipalities in the United States, there was this change, right, to the aggregate police budget of over $17 billion per year. And at that same time, healthcare and public assistance spending only increased by 5%, and community development spending did not increase at all. Okay, so let me just stop sharing for a second. I can't see. Okay.
Oh, Professor, I believe you weren't sharing the last couple minutes. I'm sorry. I was confused.
Oh, I wasn't sharing?
No.
Oh, okay.
Sorry.
Okay.
Now you start sharing again. You're perfect.
Okay, okay, perfect. So this is what I was talking about. The 1990, 12 violent crimes per 1,000, $182. 2017, we see a 56% decrease and $292. And again, we're talking about over $17 billion per year that municipalities spent on policing, while healthcare and public assistance barely kept up with population increases, and housing and community development, if you consider in population and inflation, actually saw a net decrease in funding. Okay, I was wondering where my stop share button was. Okay, so that's where it was. So, if you see today, more than a few police chiefs have responded to criticism of police officers' actions by lamenting that their officers are just law enforcers and they aren't trained to be psychologists, social workers, negotiators, or drug counselors. Of course, there's never the follow-up on why they aren't these things, why that money hasn't gone to psychologist police, interveners, right? Or violence de-escalators, but went into police as we know it today, right? So at the same time as policing became the default public service, the police themselves became more militaristic and received much more training on how to use the discarded federal military gear that had been bequeathed to them than how not to traumatize a child. And since the 1980s, police and many members of society increasingly saw crime like a war, and criminals or the people suspected of crime as evil people. So what did the police do? They trained for war. Okay, so I want to talk a little bit about, and let me share the screen again, about this 2018 study, which happened in the proceedings of which was published in the Proceedings of the National Academy of Sciences. So this researcher got a rare demographic glimpse at militarized police because Maryland had actually kept geocoded records of SWAT. Okay, and here's what he found. The author found that in Maryland, here we go, militarized police units were statistically more often deployed in communities with large shares of African American residents, even after controlling for local crime rates. And then further, the researcher found that using national panel data on local police militarization, the military policing failed to enhance officer safety or reduce local crime. Finally, using survey instruments, the author showed that the public seeing militarized police in news reports diminished police's reputation in the mass public. So just like those pictures of the federal paramilitaire in Oregon, tear gassing people and shooting them with projectiles, could have the effect of delegitimizing that form of policing. All right, so he concluded that in the case of militarized policing, this idea that we need the police the way they're policing or we won't be safe is a false choice. All right, so what does this have to do with the law? Well, I'm going to argue that the law has in many ways encouraged and enabled all of this. And the law is the reason why over 25 million people took to the streets and aren't relying on the courts to be the people who dictate the future of policing. They've done that before. The people have done that even after Ferguson. And now they're calling for political change because the law has not produced change and has not produced it quickly enough. So consider, for example, Terry versus Ohio. Everyone here probably remembers Terry stops. Well, that's a Warren Court case considered by some to be very liberal. But the case also came in 1967, right? At a time of massive protests and uprising that looked a lot like today, a time of demographic changes. But one difference is back then there was more of a mainstream acceptance of racial segregation and racialized narratives of crime. But it was precisely at that time that Nixon was stirring up fears over these protesters being rioters, looters, and domestic terrorists. And in that time, the Supreme Court was asked in Terry to decide how much power the police had to impose on people on the street. The holding of Terry served to put the constitutional stamp of approval on a practice that had been going on, but outside of the law, namely police stopping, frisking, and questioning people without a warrant and without probable cause to believe they had committed criminal activity. Now, although the Terry court did not say that such a stop was always permissible, it only required that police have reasonable articulable suspicion, which, if today you're a criminal law practitioner, you know is a completely amorphous standard between a hunch and probable cause, and totally dependent on the facts of your jurisdiction, in the cases in your jurisdiction, and what the judge is inclined to believe. Further, the court held if the police had reasonable suspicion that a person is armed, you can also do a pat down. So today we call this whole sort of bundle of abilities that the police have stop and frisk. So while imposing a fairly easily satisfied standard on police, right, when they can make a seizure on the street, although that expanded police's constitutional powers pretty significantly, people didn't really see it at the time, including the court. In fact, only Justice Douglas dissented, and boy did he dissent. He warned that this would open up a can of worms, and he really was extremely prescient on this topic. He was right. But the reason that people might not have seen Terry as such a dire case is that you could imagine reasonable articulable suspicion to be a gatekeeper. But in reality, if you look at the facts of Terry and what the court decided could satisfy reasonable articulable suspicion, you see why it ushered in a sea change in street policing. Okay, so the facts of Terry. All right, so this is taken from the case itself. You have a Cleveland police detective, McFadden. He's on a downtown beat, which he'd been patrolling for many years. He observed these strangers, Terry and Chilton, on a street corner. They go back and forth in front of a store about 24 times. Then they go and talk, and occasionally they talk to a third man, a white man, and he leaves swiftly. The police officer comes to suspect that they're walking in front of a store, looking in several times, was casing a joint, and they were going to do a stick up. Long story short, he stops them, he frisks them, he finds a weapon on Terry, and he finds a weapon on Chilton. Now, I always wondered why McFadden thought that these guys conferring and looking in an open store window in the middle of the day was a robbery to be, right? Why couldn't they have just been contemplating buying something? Did he have some special experience that we didn't know about? Why were these guys in particular suspicious? Well, in fact, the court left out a lot of facts, and here are some of them per the ACLU brief. And here's what the brief said. Although Officer McFadden had no previous information about the men and did not know them and admitted that there was nothing unusual about their dress, appearance, or their gait, he suspected that they were waiting for an opportunity to pull a stick up, despite the fact that he had never arrested anyone before for prospective stick up, nor had he ever in his entire 35 years of experience as a detective observed anyone casing a place for prospective misconduct. In fact, McFadden testified that he just didn't like them or their actions. He was just attracted to them and surmised there was something going on. And he didn't know whether, if he saw them engaged in identical conduct again, he would have had any cause for suspicion. All that was left out of Terry versus Ohio. So if you read it in the case book, you didn't read that. Also left out was this inconvenient set of facts. Terry and Chilton, right? He was attracted to them. Terry and Chilton. So from there on, things just got worse for civil libertarians. The court swung conservative, and in a series of decisions, they held that many adversarial police actions were not even stops, that being evasive with the police was suspicious, and that being in a high crime neighborhood was suspicious. And in fact, in the end, they found that police could use race as an element of suspicion. So, in Mendenhall versus US, federal agents approaching a person and demanding to see a plane ticket and asking questions about it doesn't even implicate the Constitution. We don't even have to look at whether they were racist in doing it. Just doesn't implicate it. Illinois versus Wardlow, the fact that Wardlow was running from police in a high crime neighborhood was enough to justify a stop. And finally, US versus Brignoni-Ponce. Race can be a relevant factor in determining if someone is suspicious. So a perfect example of this is the case of New York City. In 2002, the mayor reappointed sort of famed police commissioner Raymond Kelly as police chief. And Kelly had been one of the architects of the broken windows policing policy. And that policy prescribed a big, huge police presence on the street to maintain an air of public order. So at that time in 2002, when Kelly took over, the number of stop and frisks in NYC was 97,000. Under his stewardship, bolstered by Mike Bloomberg's election, that number ballooned to 605,000 by 2011. And the ACLU brought suit. And during the suit, this is what emerged. So here are the Floyd statistics. So between 2004 and 2012, there were 4.4 million Terry stops and 2.3 million frisks, right? As I explained, the number of Terry stops, rose by hundreds and hundreds of percentage points. In 95% of the frisks, no weapon was found, and in 94% of the stops, no arrest was made. Between 2004 and 2009, the percentage of stops where the officer failed to state a specific suspected crime rose from 1 to 36%. In 52% of the 4.4 million stops, the person stopped was Black, and in 31%, the person was Hispanic. In 10%, only 10%, the person was white. This is the flip of the racial statistics. New York City was 23% Black, 29% Hispanic, and 33% white. So even though New York was more white than anything else, there were only 10% of white people, or only 10% of the stops and frisks that applied to white people. Weapons were seized in 1% of the Black stops, 1.1% of the Latino stops, and 1.4% of the stops of whites. Contraband other than weapons was seized also very infrequently, but more often for whites. And in 23% of the stops of Blacks and 24% of the stops, almost a quarter, officers used force. And the number for whites was 17%. So, this is just a stark picture. These are racially disparate stops. 90% of the stops are people other than white people. And this is a completely ineffective policy. We're talking about tiny percentages of finding wrongdoing. And even in that 6% of arrests, a lot of those arrests arise because of resisting type of crimes. They're created by the stop and frisk. So Judge Shira Scheindlin of the US District Court in New York ruled that thousands of these stops fell short of even the low bar of RAS, and that the regime violated equal protection, and she ordered the police department to stop engaging in these type of stops and frisks and other sort of measures. So the law prevailed, right? Well, not so fast. The Second Circuit issued a sua sponte opinion overturning the holding and remanding to a different district court judge. Why? Because Scheindlin had requested this stop and frisk civil rights challenge under a very accepted similar case rule. And she had spoken to the press, who were hounding her for a response to the relentless attacks on her objectivity by Kelly and Bloomberg. Her offending line in The New Yorker was apparently this, quote, "Too many judges, especially because so many of our judges come out of the US Attorney's Office, become government judges. I'm independent. I believe in the Constitution. I believe in the Bill of Rights. These issues come up and I take them quite seriously. I'm not afraid to rule against the government. This was the thing that got the case overturned and her kicked off the case. And I might add that it'd be very hard for others subject to racialized stop and frisk to be able to prevail on the claims that the Floyd plaintiffs did. This case was impact litigation, years in the making, and randomly frisked people don't have those resources. Also, for a plaintiff to maintain an equal protection violation, she has to show discriminatory intent and not just statistical disparate impact. And in this case, there was a smoking gun piece of evidence. State Senator Eric Adams testified that during a 2010 discussion of the stop and frisk program with Commissioner Kelly, Adams had expressed his concerns about the program's racially disparate nature. Kelly responded that he specifically focused on young Blacks and Hispanics precisely, quote, because he wanted to instill fear in them. Every time they leave their home, they can be stopped by the police. Not everybody's going to have a piece of intent evidence like that. And in any case, the entire case was overturned. The holding in Floyd was overturned, and that is how far the law got. Exactly nowhere. But then something happened. Bill de Blasio came into office having vowed to end the stop and frisk program. And you know what? He did just that. So, the number of stop and frisks after the Floyd litigation and after de Blasio vowed not to maintain this stop and frisk program precipitously declined. And by 2017, the number was down to 11,500. That is a 98% decrease in stop and frisks from the peak in 2011. And guess what? In 2011, the crime rate had also decreased by 17%. The bottom line is that for years, New Yorkers and New York City's men of color suffered invasive and degrading stop and frisk, often accompanied by violence, for no reason. For no reason. And law has never, to this day, said that was wrong. You know, the other day, I was on a panel, and my fellow panelist was asked what lawyers should do in this moment of radical racial awareness. And he said something memorable. He said that we lawyers should just stay out of the way and let the political change happen. And I think I know what he meant. So often lawyers litigate for incremental changes, and the litigation takes years and is not fruitful and sometimes backfires because it prevents more radical change. But with just a stroke of a pen, de Blasio ended what it took years to litigate. But still, maybe it's the lawyer in me, I think that that stop and frisk litigation did have a profound effect, both on de Blasio and opening people's eyes up to the reality of racialized stop and frisk. So finally, let me note that whenever anyone talks about major reforms to any aspect of the carceral state, there's always a what about question, right? Well, if you reduce pretrial detention or get rid of cash bail or what about rape? What about domestic violence? What about home invasion? But let me be clear. These are not issues street policing is well equipped to handle. Rape's problem is a matter of getting those thousands of languishing rape kits tested and taking victims' claims seriously. And the vast majority of burglaries don't happen when people are at home, and it would be incredibly rare for the police to be able to come when called and catch the burglar in the act. Rather, what needs to happen in these situations is crime scene. And in fact, crime scene's very expensive, and they don't always send them out. They just don't do it. They say, let your insurance pay. But even if they did do crime scene, it doesn't address the conditions that created the crime in the first place. And as I explained through these stories above, putting a lot of street policing, right, or arresting into the situation can sometimes make them worse. So I detail in my new book, The Feminist War on Crime, the unexpected role of women's liberation in mass incarceration, that, for example, in the domestic violence space, there was this shift from a very service-oriented approach to an arrest-oriented approach in handling cases of abuse, and it turned out to really hurt women. Right? So I'll just end with this. I think that the first step to seeing real change in the system is, and moving towards criminal justice, is putting aside all those sound bites that we've heard over and over again about, what police do and how police save the day and how police keep us safe. And understand that what we imagine policing and the whole system of incarceration to do is very different than what it actually does. Once we understand that what policing actually does a lot of the time is assert social control over the poorest and most marginalized among us, which actually can have criminogenic effects and hurt everybody. If we understand that that's what it does most of the time, I think pulling back in the reins becomes a lot less scary. And I'll end there and take questions.
Thank you so much, Professor. So looking into the chat, I believe you covered the one on the stop and frisk. Okay, here's a new one from Jeff. Is there anything that practitioners other than criminal defense attorneys can do?
Well, I think that we all are members of that public that is part of the uprising against the built-in inertia to reforming the criminal justice system. And this inertia has been, from my research, 40, 50 years in the making. This idea that we solve social problems, including crime, through criminal law, and that is the only legitimate form of governance. I think that's something we all, as just citizens in this society, can say no to very vocally. We have a very important vote coming up, and I think that vote will dictate a lot of whether anything is done on the criminal justice reform part. But more locally, I think it depends on the position you're in, but we can talk to our local leaders, and we can talk to our neighbors, and we can talk to the DAs, and we can talk to the police about what we think the problems are. And we can educate ourselves on sort of how this all works, and whether, we are justified in this gut instinctual belief that ratcheting down policing as we know it will make us less and not more safe. I mean, I've had the benefit of being a professor in this area for 20 years. And, before that I was a public defender. So I kind of have this view through a very specific set of, research agendas and information that has come to me, has been, very channeled and specific. I think we can all be channelers of information to other people that may not know that, no, you won't have looters coming for you if we reform policing and if we reduce police brutality and have mental health units. And, actually that's a much better use of your money than policing. I just think we can tell people.
All right, next question is who litigated Floyd? Was it NAACP LDF?
I think it was Center for Constitutional Rights and the ACLU. I'm Googling it now. I'm pretty sure it was the ACLU, but I can get back to you on it. think it was the ACLU, but I can look that up and get back to you on it. I don't
Okay.
think it was the LDF, but it might have been. It might have been the LDF.
Next question. Do we know the racial breakdown of the 36% of stop and frisks when the officer didn't articulate a specific crime? Is it the same / similar as the overall breakdown?
You know, I'm not sure that that came out in the litigation. I'm not recalling that correlation of statistics. Well, you know, that would be interesting to know. In other words, they were finding many problems with what were the stop and frisk reports. They were called PD 250s, you know, and so the ones that were suspect were things like checking height. So they would do a check the box. And I probably should have included a graph of that too. I show it to my students when I teach Floyd, and it's interesting. But for example, like checking furtive glance and high crime neighborhood, you know, would automatically put you into the suspect category. And there were so many, hundreds, where nothing else was like a furtive glance and living in your neighborhood, and not like actually articulating a specific crime. But interestingly, in the case, not having articulated a specific crime wasn't fatal to the constitutionality, because again, suspicious of one of many crimes if you do headlong flight in a high crime neighborhood, but Illinois versus Wardlow put the stamp of approval on it. But it was still such a crazy thing that they didn't even they were just, this is just a suspicious person, that they kept it. So it would be good to know the breakdown, not only of that 36%, but also of how many of those PD 250s where they just were like, furtive glance, stuffing action, high crime neighborhood, were people of color versus white people. But my suspicion is they were overwhelmingly people of color, because all of the stop and frisk were overwhelmingly people of color. And in fact, the police admitted, yeah, we target young men of color because we want them to feel socially controlled, because we have this view, which, actually, I got to tell you though, even starting in the 2000s, there started to be a lot of evidence that this psychological idea that repairing, broken windows, which are visible signs of public disorder, is gonna lead to this virtuous cycle where people have a law-conforming mentality, so therefore it will reduce robberies and blah, blah, blah. There was some initial statistical proof of that, but over time, it totally dropped out, because the people you catch in stop and frisk, you don't hardly catch any, and they're not gonna stay long. And so what this broken windows policing was doing is an initial dip, because it just literally incapacitated tons of people. It just swept them up. But over time, it proved to have no discernible effect on crime rates, sometimes an escalatory effect. And they just found that this idea of social psychology of cleaning up the streets, effectuated by sweeping people in and arresting them, was not such a great idea. Maybe planting a tree, having open green spaces, doing some sort of, distributional geography, that's been shown to be promising. But this street sweeping of human beings in order to deter greater crimes, it just hasn't been shown to be a panacea. And the costs that were borne on the backs of Black and brown men was pretty enormous.
All right, we have about 6 questions left. Next is, are there any tested reforms that help address racial disparities in policing? What's actually helpful / effective?
Right. So I think one natural experiment we had in testing reforms was New York City. I mean, I showed you the graph. One way to make sure that Black and brown people aren't stopped and subjected to invasive policing that is completely unnecessary, possibly criminogenic, and really destroys the bonds between community and police, is just telling police, really, unless you've got a lot of suspicion, don't stop and frisk. And that will increase everything. It will increase the accuracy of when they're predicting that somebody's actually doing crime, and it'll reduce the amount of people who are policed, which will, when it's disproportionately Black and brown men, Black and brown men will disproportionately benefit. And, that's not to say whatever, smaller number of stop and frisks might not have some racial bias in it. But an across the board policy of just stopping this racialized practice worked the best. And here's, really something that's telling. For years, they had been doing racial sensitivity training. They do it now. They make you take these tests that prove that everybody is implicitly biased and that your, eyes move to the person of color when you hear bad and move to the white person when you hear good. Well, you can do all that, right? But if you are deploying police to places that are defined as high crime areas, and studies have found that high crime doesn't actually correlate to high crime, because in many cities, where the most crimes occur is where the most property crimes occur, and where the most property crimes occur are in the richer neighborhoods, right? Those are the high crime neighborhoods. But high crime is just a proxy for race and poverty. If you're deploying officers disproportionately to there and saying deal with people, and officers are also trained, even if they're trained, don't do it to a black person, don't do it to a black person. If they're trained that everybody out there, and I went through a police training, is a killer, and if you don't kill them, they're gonna kill you first, you pull your gun pretty quickly. You pull your taser pretty quickly. And the combination of, teaching police falsely that the way to protect themselves is to use a lot of brutality, which it's like not very protective. And if you tell them, go deal with a lot of people, and then you deploy them to low-income neighborhoods, no amount of training in the world is gonna stop the bad racial result you have there. So for me, this training, body cams have been found to be ineffective. And in fact, body cams can record a lot of incriminating evidence against suspect. Why? Because guess who the body cam is not filming? The police. Guess who the body cam is filming? Y'all, right? All of us. So these have been found to be ineffective and possibly harmful to the community too, which is why, you less often see the body cam footage than some bystanders footage. So all this is to say, I think the right direction is that de Blasio direction. I talked to one of the DAs a few years ago who was stopping by CU. And they said, we have a mandate this year to try to reduce our jail population by 7%. And we just met it. That's what they had to do. They just decided that the DAs, 7% less would be good. And they picked the cases that they were going to null pros. This is people choosing to do things that really make a difference instead of sort of talking about things that make you feel like maybe they're making a difference, but in reality they're not. And the reason we're not doing the bigger thing is we're really, really scared about this depolicing. And there will be the news that focuses on that one crime to undo the entire program. So, my feeling is these have to be programmatic, large scale, redistributing, reshuffling, retraining responses. And those are very scary. But if there was ever a moment to have responses like the de Blasio response, it's now. De Blasio's not doing the de Blasio response now, but he was then, right? So, that's a big thing to say. I'm just gonna basically take the entirety of the stop and frisk program and bring it down to 2% of itself, but it happened.
All right, next question. In your interaction with legal scholars and law students, is this something that's becoming more widely known? Is there a trend that shows a closing of the knowledge gap?
Well, the students, and of course, this often cuts along political lines, like Democrat-Republican lines. But for the most part, and it's also a function of we're here in Boulder, and most students do go towards that Democratic, more progressive line. But the students are fired up. The students are, I've been teaching this for 20 years, and I guess I probably shouldn't disclose this, kind of teaching it kind of the same way for 20 years. So I've been talking about, the statistics and the racial disparities and the training and the implicit bias. And, people are like, really, that sounds like a fringe thing. Now, the students are really like, wow, how could you, professor, how could you even teach this? This is just a system of, oppression. So they're really fired up of it. What I found that, and maybe it'll be different in the spring when I teach Crim Pro, I found that cases of police being overbearing, including, obviously there's a racial disparity, but there were many innocent white people subjected to stop and frisk and violence. I find that even right-leaning students are surprised when they hear about how many rights the Constitution doesn't seem to grant them when it comes to the police. Now, I wonder, now that with the protests and the counter protests and everything that's been going on, it's been so politicized, whether, more conservative students, will be farther away from the more civil libertarian side. But I actually found that for most of my students, and this was even true when I taught at Iowa and in Miami, so not just in liberal Boulder, it was just a matter of how much they had an objection to what the police could do. But most of the students had an objection, and now I think they are hyper aware. What they're going to do about it, I don't know, and whether they're even going to go out and vote in November, I don't know. But it seems like they're more aware than ever.
Next question. Can you say more about the negative impact on women from the shift away from service responses to DV to arrests?
Yeah, it's really a counterintuitive thing that happened. And I could probably go on for, I think I only have like 5 minutes, but I probably could go on for 30 minutes on that alone because it's 3 chapters of my book. So basically, I'm going to start in the 60s. I told you, time of protest, really time of left protest energy, and we have the start of the battered women's movement. And the battered women's movement was incredibly anti-police, anti-authoritarian. They came during that sort of free love and hippie and protest time. And so the number one thing was shelter, right? So shelter, services, anti-poverty, and maybe some of the feminists were like also, housewife wages, women working. But there was a certain group of feminists that ended up being powerful, and not surprisingly, they were the lawyers. And they had represented a subset of battered women whose cases had sort of made it to court. They were either suing for divorce or suing for protection orders or for child support or for money. And they had a very consistent story, a lot of these clients, that they were very badly beaten, really wanted the police to intervene, and the police had refused to intervene. And so they went through years of suffering for nothing. And this was totally part of the story. That, there were a subset of women who were really begging the police to arrest, and there were a subset of police who just for a host of reasons didn't arrest. So there was this impact litigation very similar to Floyd, where the lawyers basically sued the police departments saying women had a right to the arrest of their batterers. And one thing led to another, and these cases settled, and then discourse came up. There were some high profile battered women who had died or killed cases, and the police departments got really on board with it, and they decided that instead of giving police the discretion whether or not to arrest, they would adopt these pro and mandatory arrest policies. So the very consistent idea in the feminist literature, and the one I grew up with before I started writing this book, was that, okay, the reason police were exercising their discretion not to arrest was because they were pigs and they were probably beating up their own women. Now, I'm not saying that some of these police weren't pigs who were beating up their own women, and that there aren't police, pigs who beat up their own women now. We hear about this all the time. But first, I would say there are plenty of police out there who do plenty of violent crimes to their loved one, friends, and just randomly, but still have no problem arresting somebody else for that crime. So that's the first thing. And the second thing is, when you look closer, and there was a lot of testimony collected back then because there was this whole massive federal study on DV, Police had some nuanced reasons for not arresting. They included that they believed that arrest would increase this cycle of violence against women because they couldn't keep a misdemeanor in jail forever. They, knew that a lot of the women were financially dependent on the men, and even 2 days in jail, he'd lose his job and they'd all be poor and they'd be homeless. And the number one reason they didn't arrest was because the victim asked them not to. So, okay. So now you can imagine what happened when, discretion could never be exercised. So all the police had to arrest. So they had to arrest whether the women wanted it or not, whether it would put the women in more or less danger. And, eventually, as this policing got less community and more militarized, the police loved these feminist policies because they're like, we're not social workers. We don't have to mediate anything. We just want to arrest, right? And so by the time of the late 80s and early 90s, you had many, many jurisdictions and many, many police departments adopting mandatory and pro-arrest policies. And then the studies started to come out. So the first study that came out was a very limited study in Minneapolis. It was the Minneapolis domestic violence experiment, and it's still the one that people remember. And it showed police to have some effectiveness at deterring future violence. But it was only a 6-month study, very small study. And that same researcher and his team did larger scale studies in a bunch of cities, including Colorado Springs, incidentally, and in Milwaukee. And they found something very interesting. Over the long run, and the long run was 2 years, right? So that wasn't even the long run. Arresting versus doing other things like, mediating out the situation or just removing the person temporarily, increased violence significantly, especially amongst unemployed men of color. So in a city like Milwaukee, and across the board of arrest policy, the researchers found could decrease the chances of violence for, the wealthier white women, but at the cost of twice the amount of violence against poor Black women, right? And this is not to mention that when you put police in there and say arrest, 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 many of these women end up getting arrested. Many of the most marginalized women who would otherwise call the police, don't call the police because they don't want to be arrested for sex work or for drugs or for abuse and neglect of their own kid. And so one of the studies found, this was a 2007 study, that actually mandatory arrest policies were correlated with higher levels of domestic homicide. And one of the hypotheses is, if you've called the police before and it was a mandatory arrest and it wasn't what you wanted, you're less likely to call the police, and it might be that one time where the police could have intervened in what escalated to a homicide. So there's way more I can say about that, but that's just a little tidbit about how a very well-intentioned program in the name of women's equality ended up really harming the poorest and most at-risk women.
So it looks like we just have one last question. It is, could you further identify the source for the study on crime rates in municipalities? It would be great to have a link or name to be able to read more about that. Thank you.
Yes, I can link that to you. In the chat, I have our, Brendan Beck and I wrote an op-ed on it. And Brendan Beck really did, I was the law professor. I was the law professor slash op-ed writer, and he really crunched the numbers on it. But I believe he got a database of municipal expenditures and the crime rates he got from the FBI uniform crime reports. But let me put this. It has the links to all of it in our op-ed. So you should be able to link to everything. And if you reach out to Brendan Beck, who is my co-author, let me put the chat up here. Here is the link. If you contact my co-author, he has Denver specific, he's also crunched the Denver specific numbers on it.
Excellent. I think that is it for questions. So Professor Gruber, thank you so much for joining us today, and thank you everyone for participating in the CLE. That link is there. I will also send out the link when I send out the CLE form for today. And if you have any more questions, you can send them to me and I'll pass them along to the professor and potentially get them answered. But otherwise, thank you, everyone.
Thank you. And let me mention that if you're interested in the book and more discussions of the DV and sexual assault and those issues, I'm doing a book talk for Boulder, Museum of Boulder and Boulder Bookstore. I think it's October 1st, but yeah.
Perfect. We'll try to put that on our social media, just remember. So thank you again, Professor, and thank you everyone for joining us.
Thanks.
Have a good day,
Bye.
everyone.
Okay, thanks.